I'm Drew Stevenson, and this is a lecture for my administrative law class about the case U.S. Army Corps of Engineers versus Hawks Company. This is a 2016 U.S. Supreme Court case about requiring final agency action for judicial review. Quick word of intro to my students. We have a section in almost every administrative law casebook about the timing of judicial review. And what all of these concepts are about is that sometimes you can run into court when you receive an adverse decision from an agency, or an agency does something you don't like, but you've gone to court prematurely and the court kicks your case back out. And so one of our kind of rules about the prerequisites, so to speak, before you can seek judicial review is that you have a final agency action. Sometimes this is going to be easy, and you'll know you have a final agency action because the agency sent you a letter that says in bold print across the top, big letters, final agency action. And so that's not always, but that's a good indication that you might have a final agency action. On the other hand, sometimes it's not so clear because maybe this was a preliminary determination from an agency and there's something to argue about. On the other hand, maybe your client feels like there's a final agency action just because the agency has acknowledged receipt of their application, or that their application is now complete and they're reviewing it. Well, that's not going to be a final agency action. And so the issue matters. And even though this is usually taught at the end of the administrative law course, it's actually one of the things you really have to watch for in practice, along with ripeness for review and the exhaustion of administrative remedies. So let's look at what happens in this fairly recent U.S. Supreme Court case, Hawks Company. We start with the statute, and the statute in this case is the Clean Water Act. The Clean Water Act prohibits the discharge of pollutants into waters of the United States without a valid permit. Now, I don't want you to get confused. We have two agencies that are players here. The Environmental Protection Agency, or EPA, which is not part of this case, actually runs the permit program for pollutants, and these permits come with a lot of strings attached. The determination about what counts as waters of the United States is made by a different agency called the Army Corps of Engineers. And so what this means is, if you're a landowner and there's, let's say, a pond or some swampland or something like that, or a creek on your land, and the Army Corps of Engineers says this counts as waters of the United States for purposes of the Clean Water Act, that means it triggers all of the provisions of the Clean Water Act apply to your property. And that means you're going to have to get permits for things. It means you're going to be limited in what you're allowed to do. In other words, you might want to do something in the EPA says, no, you can't get a permit for that. So it can affect what you're allowed, how you're allowed to use your property, and the permitting process can take a long time. So it can delay projects and developments and so forth. So it has a lot of consequences. Deciding that your land has waters of the United States and therefore it triggers the application of the Clean Water Act has a lot of consequences. And so how do you know if the little pond on your property or the little marshy area after it rains counts as waters of the United States? So that's hard to know. So sometimes, because it's difficult to determine that, the Army Corps of Engineers will do you a favor and issue you a jurisdictional determination. That's what we call it, on a case-by-case basis. And it will specify whether your property contains waters of the United States and therefore triggers the application of the Clean Water Act to your land. Now, in this case, the Corps had issued a jurisdictional determination stating that the property owned by peat mine operators in Marshall County, Minnesota, included waters of the United States because it contained some wetlands, like sort of marshy, swampy areas. and the landowner is the Hawks Company. That's the peat mine company. The mine operators filed suit to challenge this jurisdictional determination because remember, this is going to trigger a lot of restrictions on what they can do on the land and force them to get permits that take a long time and cost a lot of money and so forth. So the critical question in this case is what counts as a final agency action, and that's a prerequisite for judicial review under the APA, or Administrative Procedure Act. Now, here's the spoiler. The court is going to hold that this is a final agency action, which is not what the Army Corps of Engineers wanted. So they're going to say that this is a final agency action and therefore is an appropriate subject for judicial review. Now, you may be wondering, why doesn't the Army Corps of Engineers want their jurisdictional reviews to count as a final agency action? Because they're issuing a lot of these, and in their minds, this is just a preliminary answer to a question of whether they think the Clean Water Act applies to the water on your land. But now every time they do this, they might have to litigate it. And so that's a bit of a game changer for the agency. Something that the court does here that's really noteworthy and a reason to read the case is it actually sets forth the final agency action rule as a two-part test. Not all cases do this, or commercial study aids explain it the same way. This idea of final agency action, I'm not even sure my case book that I use explains it as a two-pronged test, but this is a recent US Supreme Court case, so you can count on this. The action must mark the consummation of the agency's decision-making process. It doesn't have to be all the decisions the agency makes, but a decision-making process by the agency basically has been consummated and complete. They're done. They're maybe closing the file at this point. In other words, they're not just accepting your application or acknowledging receipt of your application or telling you that your case is under review. They're not looking at it anymore at all. They've made a decision and they have moved on, let's say. Also, the action must be one by which rights or obligations have been determined or from which legal consequences will flow. So the agency making a decision that doesn't affect anything or change anything for you might not count as a final agency action. And again, my example of the agency telling you that your application is complete, or acknowledging, even soliciting that you reapply, or encouraging you to renew your license or permit, or telling you your license or permit is up for renewal, well, that doesn't really change your rights or obligations, right? So this can be confusing for non-lawyer clients who sort of think that every piece of paper they get from the agency that's in writing is an agency decision and feels very final. And as a lawyer, part of your job is to sort this out and figure out, has this decision by the agency created some rights or obligations that have legal consequences? Now, remember, in this case, the Supreme Court, it's not that surprising to me that they decided these jurisdictional determinations have a lot of consequences. I mean, actually, this has a direct and immediate effect on your property values. If your land has federally protected wetlands and you can't build, for example. So what does the Army Corps of Engineers say? They issued this JD, and a jurisdictional determination from the Corps, like the one in this case, the US Supreme Court says, satisfies our first condition because it marks the consummation of the Corps' decision-making on the question of whether a particular property does or does not contain waters of the United States. By the way, I don't think this is a terribly interesting question, but I can imagine a class discussion where we could get class members arguing each way on this issue, whether these preliminary determinations should count as a final agency action or not. The court also says that these jurisdictional determinations are issued after extensive fact-finding by the Corps about the physical and hydrological characteristics of the property. In other words, they usually come out and do an inspection, take some measurements. They look at maps, like topographical maps and so forth. And they definitely study how close you are to other bodies of water or creeks and gullies and things like that that feed into rivers and lakes and larger streams. And also, when you get one of these jurisdictional determinations, it's valid for 5 years. In fact, the Corps itself has previously described these jurisdictional determinations as final agency actions. That's sort of right by your own words. So they've been calling it a final agency action. And then in this case, they say, no, it's not. So the court also says the definitive nature of these gives rise to direct and appreciable legal consequences. As I said before, this means there's gonna be all sorts of limits. The Clean Water Act applies to your land. And so you might not be able to build or conduct certain businesses or activities on your property, or you might have to get permits from the EPA and so forth. Conversely, a negative jurisdictional determination. So a jurisdictional determination saying that you don't have jurisdictional waters for purposes of the Clean Water Act gives you a 5-year safe harbor from enforcement proceedings. In other words, if you have one of these letters, the EPA can't bring an enforcement action against you for not having a permit or doing something you're not allowed to do under the Clean Water Act. You went and got the letter that said the Clean Water Act doesn't apply to the water on your property. Now, on the other hand, a final agency action is reviewable under the Administrative Procedure Act only if there's no adequate alternatives to the APA review in court. And the court doesn't really, remember in an earlier slide, I said they had a two-prong factor. Some professors would call this a third prong. I think the court is treating this as an exception, that they're saying, by the way, the exception doesn't apply here to final agency action, which, and that would be sometimes we will sort of by judicial construction or by construction say we're going to call something a final agency action if it really is a dead end for you, right? If you don't have any adequate alternatives besides judicial redress at this point. So sometimes the court will sort of create almost as a legal fiction a final agency action, or it's probably better to say they'll just make an exception to the requirement for you sometimes when you're really going to be stuck or out of luck. You could almost think of this as like an equitable type exception. The Corps said they have alternatives. So the Hawks Corporation could just not get a permit, even though we've said that the Clean Water Act applies to their land. And then later, if the EPA brings an enforcement action, they could say, well, we shouldn't have had to get a permit because we don't think that we have waters of the United States on our property. The Army Corps of Engineers was wrong way back when they made that determination. Or if they're scared, they could play it safe and go ahead and get a permit process and then challenge the requirement and seek judicial review and say, we got a permit and now we want a declaratory action that we never needed one in the first place. Well, the Supreme Court, by the way, this drawing is from oral arguments of this case, rejected this and said that's really unfair to private parties. Landowners shouldn't have to wait for enforcement proceedings before challenging a final agency action where these proceedings carry the risk of criminal or civil penalties. And the Clean Water Act, you can face some pretty hefty fines if you just ignore it. Also, the court notes that the permitting process is not only costly and lengthy, but it's irrelevant to the finality of the approved jurisdictional determination and its suitability for judicial review. In other words, the permits and the permit disputes are with a whole other agency. And whether your permit is valid and so forth is a very different question than the question the Army Corps of Engineers has answered. And the Army Corps of Engineers is done with their part, so to speak. Also, because the Clean Water Act doesn't make any reference to standalone jurisdictional determinations, the court says there's no basis for inferring anything about it from reviewability. So I want you to think about what's going on here. The Army Corps of Engineers is saying, by the way, this can't be a final agency action because these jurisdictional determination letters aren't even in the Clean Water Act. They're just something we're doing as a kind of service to landowners. And the court says, just because the Clean Water Act doesn't mention these letters you're sending out doesn't mean that we can't infer anything that these letters are in fact a final agency action or represent that for purposes of judicial review. I'm worried that you're getting bored because this isn't that exciting. And so here's a picture of my dogs, Lucy and Rosie, telling you to stay focused for just a few more minutes. Okay, I've made a little diagram for you. By the way, I have a separate video tying these three things together that I'm afraid you won't watch, so I'm going to give it to you here too. We have three types of timing requirements for judicial review of agency actions: final agency action, ripeness, and exhaustion of remedies. Make sure that you are aware of all three and try, even though they all overlap. They're all about timing. They're all about bringing a case prematurely into court, but try to have in your mind how they're different from each other. And remember, judicial review of an agency action will be premature if we don't have any one of these three things. So if you don't have a final agency action, your cases, you shouldn't be going into court yet. If it's not ripe for a review, you shouldn't be going into court yet. And if you haven't exhausted your alternative administrative remedies, you shouldn't be going into court yet. And if you do, courts are going to dismiss your claim. So what do we mean here? This is the quick and dirty. A final agency action, we're going to ask, has the agency rendered some kind of final decision on a matter or published a final rule? Or we could harken back to the two-part test that I have earlier in this video of does the decision mark the consummation of the agency's decision-making process, and does it trigger legal rights or responsibilities? Ripeness, I have a video where I talk about this in regard to Abbott Laboratories v. Gardner. This is the question of, is a matter fit for judicial review, in that no more factual or legal issues need to develop? And also, will there be hardship on a party if they wait until an enforcement action to challenge the rule? So even if we have a final agency action, like we did in the Abbott Laboratories case, it might not be ripe for review, or maybe it will be. Exhaustion of administrative remedies, we ask, does the claimant still have some alternate administrative remedies, like an agency hearing, that haven't been used or exhausted? With that, there's an exception, right, to the exhaustion of remedies requirement, or you could see it as a second prong if you want, about that we call futility and harm. And so one example of futility to exhaustion of remedies would be if the agency took an adverse action towards you and then said, you can request a hearing, but we're not changing our minds no matter what, then you could tell a court maybe that it would be futile for you to go through the agency process, the agency's hearing process. You're unlikely to win, but sometimes people do. Or let's say you tell the court, look, if we're a restaurant or a bar and our liquor license has been revoked, and if we can't run our business without it, so we're going to be bankrupt if we have to wait around because of the backlog in the agency hearings. And so that's almost sort of equitable relief or exception that you're asking for, that basically you really can't, because the case will be mooted because you won't exist anymore if you try to exhaust your administrative remedies. Again, you're probably going to lose, but you can try it. Okay, here's a review question to see if you've been paying attention. Which timing requirement for seeking judicial review of agency actions was at issue in the Hawks Company case? A, final agency action, B, ripeness, or C, exhaustion of administrative remedies. I know I mentioned all three of these at the end, but the Hawks Company case was about one of them. And if you don't remember, maybe you should go back and review the video. That concludes our little lecture about the Army Corps of Engineers versus Hawks Company.